please hear me out. If you act on the wrong version of the law, you can genuinely lose your job, ruin a legitimate claim, or walk away thinking you have protections that just don't exist. There is a massive, widespread misunderstanding of psychosocial risk and psychological hazards at the workplace. So in this video, I'm going to walk you through what the law actually says, what it doesn't say, and the exact steps you can take if you think your workplace is putting you in psychological harm. My name is James Glisson. I'm a lawyer and I teach law at university, and every day I help people understand what legislation means and what it actually says, not just a popular version that people want to hear. And I want to be very clear, the creator of the Australian viral videos on psychosocial risk at the workplace is doing an important job in terms of raising awareness. So let's start with what psychosocial hazards actually are. Under the work health and safety regulations and consistent with the code of practice, psychosocial hazard is something in the design or management of a workplace that increases the risk of psychological harm. Examples include bullying, harassment, violence or threats, traumatic events, unreasonable or unsafe workload, extreme job demands, role conflict, and organisational dysfunction. The second reading speech is clear. These laws exist because psychological harm is real harm. They weren't created to punish ordinary stress. They were created to ensure that workplaces manage real risks and take them seriously. But here's where people get confused. Psychological harm doesn't work like physical harm. If people fall off of a roof, the injuries are likely to be the same, assuming that the roof is the same height. Psychological harm exists on a spectrum. From the same original event, you may have 5 employees who suffer totally different levels of harm, from being unaffected, to frustrated, to moderately affected, to severely affected, to completely incapacitated for the future. Now that makes it extremely hard to know how to deal with the harm and how to deal with the potential risk of harm. And the legislation is drafted quite broadly in terms of its definitions and thresholds, and that, simply put, is because there is no universal threshold. That's why the legislation uses terms like foreseeable risk or reasonable steps and reasonably practicable. Not everything that feels bad and anything that you suffer from is a breach. Now let's get clear on one of the biggest myths. Your boss is personally, criminally liable for your psychological health. The primary duty holder is the PCBU, the workplace, business, company, whatever you want to call it. They are responsible for ensuring the health and safety of their workers as far as reasonably practicable. Next, you have the officers, directors, or senior executives, who have a duty of due diligence. But a manager or supervisor is by no means automatically the person who's liable, and personal liability only arises if the PCBU breached its duty and the officer failed to exercise the due diligence. Most of the time, individuals are not criminally liable, the business is. Another viral claim is that your boss can go to jail for simply stressing you out or causing potential panic attacks. Imprisonment is reserved for what is known as a Category 1 offence, being reckless conduct that exposes a person to a risk of death or serious injury or serious illness. So in this context, serious psychological injury would mean clinically significant diagnosed impairment, not frustration, stress, or a panic attack. And by the way, it's almost unheard of for a psychosocial injury to reach a Category 1 threshold, and nothing in the reform has changed that threshold. So what does this look like in real life? I'll give you a scenario. A worker is exposed to constant threats of violence, bullying, and humiliation. The business ignores her repeated requests over days, weeks, and months. This is a foreseeable psychosocial hazard, and the business can absolutely be liable. Now contrast that to a second scenario, where a worker feels stressed because of workplace change, but the business has consulted the employees, communicated their understanding, and provided, more importantly, support. It's uncomfortable, and the feelings may well be valid, but it's not a breach. And just to tie it off, a third scenario in which a worker accuses their manager or boss or the company of a WHS breach, specifically a criminal offence under these rules, because they disagreed on workload. They get dismissed. Now, yes, they can challenge the dismissal, and the dismissal may not even be fair, but that process is a long, stressful, and expensive process. which is exactly why relying on this information can backfire horrifically if you don't make sure it's coming from a reliable source. It's also why it's so important to get proper advice, and guess what? We're going to go through what you can do and how you can get that advice if you feel like you are facing significant harm. So if you genuinely believe that work is harming you and it falls within the definitions of what we've already discussed, here are some actionable steps you can take. 1. Document everything. Times, dates, witnesses, descriptions, and do it as soon as you can, because the sooner you document it, the more reliable it's deemed to be. 2. And you may disagree with me on this, but use internal processes, HR, maybe even a WHS rep. The reason for this isn't because, well, they're going to take it seriously. They might, and they should, but it's because that will provide an internal document that can later be used if needed. 3. Speak to a GP or psychologist. It's important to get these things assessed from professionals who are able to give the opinions that will be required. 4. If the issue is serious and the risk is real, contact a regulator. 5, and this is important, get proper legal advice. This is not legal advice, this is just information and trying to clear up some misconceptions that are being pushed online. For this to be legal advice, I would need to be able to speak with you personally, get proper instructions, and provide a proper detailed advice. This isn't that. Now, the reason that I say it's important is because in order to make sure that you are making a good decision and not a bad one, you need proper advice. Most people get into trouble not because the law failed them, but because they relied on bad information and they got the law wrong. Don't do that. If you've watched this far, you care about getting the law right, and that's a great thing. If you want more explainers like this, or deeper breakdowns of areas of law, I post regular content on TikTok and am going to be posting regular content here. Leave a comment with an area of law that you're interested in and I will make an explainer video for you. And please share this video with somebody who may be confused about psychosocial risks and psychosocial hazards. Clarity protects people and confusion puts people at risk. You may just be saving their job. I'm James Glisson and I look forward to answering more of your questions and posting other deep dives very soon.